Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or appropriate dispute resolution in a bid to attract more users to settle their disputes or conflicts with mediation, arbitration, negotiation, collaborative law, conciliation, and early neutral evaluation. My name is DrChinweEgbunike, postdoctoral fellow at the University of Brighton, United Kingdom, and a fellow of the American Bar Association section of dispute resolution. I am delighted to welcome Herschenia A to the EVER show. She serves as the Vice Chair of Programming for the Diversity Committee of the American Bar Association Dispute Resolution and on the Advisory Board for the National Workplace Bullying Coalition, which is working to pass legislation to recognize bullying in the workplace as a toxic epidemic and create accountability. She is an employment mediator, corporate consultant, arbitrator, speaker, and Amazon best-selling and award-winning author. She wears many hats, so I've left the link to her profile below. Welcome to the show.
Thank you so much. Thank you for having me. Thank you for having me. I wanted to say I'm a FINRA arbitrator, so hopefully I can get into the American, AAA, so American Arbitration Association.
Oh, cool.
Hopefully one day. That's the goal.
Fingers crossed. All right, so without further ado, the first question is there any difference or impact on the cost and time frame for settling disputes via ADR compared to litigation?
So I guess it depends on the type of dispute. So I do more so civil disputes for the courts out here in Texas. I'm from Chicago, so you might see my shirt. I have on the White Sox shirt, but I moved out here to Dallas, and I volunteer for a couple of the court systems here, maybe a third one coming up soon. And those are, by the time the cases get to me, those are actually like set maybe 3 weeks to a month before trial. So they would have been in litigation for a couple of years, maybe about a year and a half to about 3 years. And it depends on if it went from one court system to another, like if it was originally in JP court, but it depends on JP court handles different types of cases. So it depends on what type of case it is. If it's a civil dispute or if it's a workplace dispute, then the parties can hire attorneys at any given time. More than likely the company will have their own set of counselors. They will have their own legal representation. And then you will have the person that's more than likely the plaintiff would be the former employee, or if they are still employees, that could be the case too. They're still an employee working for that particular organization. They will seek counsel unless they go pro se, which means they're representing themselves, as you know, or if that be the case, then they could at any time decide to go through mediation to work out the dispute. But in terms of time and cost, it's always good if you're going to mediate and try to settle. It's always good to try to do that sooner rather than later, because the expenses kind of drag out. They accrue after a certain period of time. If you're going through litigation, of course, you're going to be going back and forth to court. You might have to take off work. You're paying for your attorney fees. So it's a lot of additional costs that's included the longer that the dispute is played out.
Okay, so with mediation is a lot cheaper and easier to settle the mediation when compared to litigation.
I don't know. Well, I would say it was the cost factor is definitely a factor. I don't know if it's a lot cheaper. It depends on at what point in the dispute are you seeking mediation to settle.
Okay.
If it's earlier, then yeah, you will save a lot of money. If it's later, then you would have still paid for all of the costs associated with going to court, and including the mediation. Because with the mediator, the costs are split out, but depending on if the dispute goes on for an extra mediation, most of them are resolved in a day. Some can go up to 5 to maybe a week or 3 or 4 days. But it's definitely worth an investment if you believe that you want to have a creative solution and you definitely want to get settlement right away. or try to settle right away.
Okay. All right. Thank you so very much for that. So, are employees or workers aware of the ADR options available to them regarding disputes or conflicts at their workplace?
And that's also depends. So
Yeah.
if it's within your employment contract, and a lot of times when you sign your employment contract when you're first onboarded, you don't really know a lot of the options. You're just kind of signing it. They may go over it when you're going through your what is it at the very beginning? Orientation. They may or may not bring that up. There may be to where they have something on their newsletter, on the website for options. And it may be to where you work in a department where your manager, if they know that there is a concern, they may bring up that these may be your choices, unless you go to maybe HR or you do some research. A lot of companies don't have, a lot of organizations don't have an ombuds in place. Some do. Most ombuds are in higher educational institutions like colleges, universities. But in terms of organizations or corporations, they don't, unless they're like really big organizations like a Shell or a CVS. I'm just saying out, just speaking that out, just rattling off. I don't know if CVS even has an ombuds anymore in place, but unless it's like a huge organization, an ombuds would probably be a great point of contact for a person if they have conflict, to know what their options are for that particular conflict. But like I said, most companies don't. That's a push that we're trying as a member of the IOA. That we're trying to push advocacy towards, I wouldn't say advocacy, but more awareness and exposure towards having ombuds offices established in corporations. So they'll know that that's a very valuable and beneficial role to have in place for any ADR or concerns, for conflict concerns or dispute resolution strategies that could be put in place.
Yeah, did you say IOA? What does that mean?
IOA is the International Ombuds Association.
Oh, okay. All right. Thank you so very much. Okay. Yeah. Okay. So, but do you know anything about the private organization? Are their employees aware?
I'm sorry, can you repeat that?
About private organization, is it the same thing in private organizations?
For having an awareness for the employees?
Yeah.
So that's a good question too. I hate to use this as another answer, but it depends. I do see that there is like I said, a push now I'm seeing more people reaching out to different ombuds networks like the IOA and maybe some other networks, because you can be an ombuds and not be part of the IOA, but maybe part of a different network, or maybe not. But I am seeing that there are more smaller organizations and nonprofit organizations that are researching what kind of options that they have in place. Because when you're a smaller company, you don't have a lot of resources for employees. You might have a person that's contracting as a human resources, or somebody that you have on staff as human resources. You may have a consultant that helps you to navigate that, or maybe not. And that may be that the consultant is not really as well versed in conflict resolution strategies. But we are, in terms of private in private organizations or private companies, it depends on how big they are and whether or not they have an ombuds or a workplace mediator that will be like a third party person in place. I do know that some companies, for like in terms of mediation is concerned, like I said before, they have already their own counsel, whether they are part of the company or not. Most of the times they're part of the company, but they may have outside counsel that helps them with that. But that also depends on the comfort level with the person that has the concern. Because if a counsel is part of the organization, the person that's having the employee that's having the concern may feel like that's probably not, there may be some bias there, so they may not be willing to share or know what the options that they may have.
All right, thank you so very much on that. So, in line with your article, how bullying and discrimination intersect in the workplace, and why ADR is a solution to it. So, to what extent are employees encouraged to use ADR to settle discrimination, harassment, and bullying in the workplace?
So they can have a number of circumstances, and there's like a push for people to really understand that there is a distinction between the two. You can have bullying that happens as a result of a racial situation that has occurred, like a microaggression. And some people are not even, some companies might not understand or know what a microaggression is, or what has taken place, or the harm or consequences that follow a microaggression that a person has experienced. We're trying to, I'm kind of working with the, in a small subset group of the National Workplace Bullying Coalition. We have a DEIB group that's established with just a few of us, and we're actually doing a presentation. We're trying to schedule for this later this month on how that intersects and what that means. Yeah. When those circumstances occur, a lot of times people, if you're in an organization, they may or may not go to human resources. They may, or because the pushback may be to where they might not feel comfortable with sharing it with human resources. They might not believe that there is going to be any consequences or anything that would be done to stop. And not having an ADR design or system in place for people to have options to go to is actually makes people a little uncomfortable with sharing. They will share outside with their family or friends, but they may not have anybody that they feel comfortable with going to. And then there's the issue of, if I do share this with HR, or if I do talk to my manager, will there be retaliation? Like, how would that happen? But a lot of companies, if they had some type of dispute resolution design in place, not just a employee compliance hotline, or employee compliance or departments, where all of these are supposed to be confidential, but they also are formal channels. Sometimes I bring up ombuds again because it's very important. Ombuds is that informal channel that people can go to. So again, there's their push to get an ombuds office established, to get a charter established, to get an ombuds in place, because an ombuds can really help to provide some type of solution. I don't want to say solution, because it's more so the person, the visitor that comes into the office, but give them options and empower them to make their own decisions as to what resolution channel they would go to for their particular concern.
All right, thank you so very much. So is there any motivations for the employees?
Motivation in terms of?
In terms of encouraging the employees to settle via ADR, is it mandatory for people or for employees or for employers to settle via ADR first before going to court in the state where you are?
I don't know about mandated. It depends on what's in the employee's contract. So some organizations do have it set up to where if there's a dispute in place, they have an arbitration clause within their employee contract. So it may be to where if the conflict is right for arbitration, that will be the direction it will go. But in terms of seeking there are some, I have seen some cases where employees or organizations or corporations will have something in place to where it has to go through a channel, because they have to show like due diligence that there was a strategy in place, that employee took those steps before it escalated. So I have seen that before as well. Encouraging an employee would be to where there is, again, some communication that is established. There may be like some training that's mandatory for a supervisor or a manager or somebody in leadership to have, especially if they have people reporting to them, maybe on effective communication or things of that sort. But in terms of outside of that, that's really the company's decision to really push out and encourage people to take certain steps, or what their what their options are if they do have a conflict. I can't stress this enough. An ombuds is there to provide that service.
You keep talking about ombudsmen. How about
Yeah.
mediation? Because here in England, they encourage, and in Nigeria as well, mediation, and conciliation, in settling workplace disputes. So, is there? Don't in the US, don't they use mediation to settle workplace disputes?
Oh yeah, they definitely do. So you can have so a person can go, like, if they have an issue with their employer, if they gather enough information, the EEOC or EEO is a great resource as well. And it
Sorry,
depends.
EOC, what does that mean? Sorry.
That is let me see. That is the employment. I'm going to get it wrong.
Okay, no, that's fine. Maybe after the show, you can test, you can send me. So let me just write it down.
I want to say
sorry.
equity or something, but I can't remember. If we could do some research, because I can't remember the exact what the acronym stands for exactly. But that is normally the commission or the route of resource that people will go to outside of their place of employment if they feel like, okay, there is definitely some wrongdoing here. Maybe there has been a law that was violated, and my company the company that I work for is not taking action quick enough or taking the right action. So they will move into that space and to seek the EEO, EEOC, and the EEOC will do some investigation to determine whether or not there was wrongdoing or a violation of the law, of an employment law or labor law. I don't know about labor. I know employment because I feel like there's a different section with labor, but I don't know. So you have to do your research on them and contact them to see what benefits would come with speaking with them and from their investigation. But they do offer mediation. They do have mediators there, and they do offer it, but it has to be to where both parties agree. So the person that's filing the complaint through the EEO, EEOC, and then also once they reach out to the organization has to say, yeah, we would like to go through mediation. Because a lot of times that would be a great option, so that before litigation. So at the point where it's litigation, you got all kinds of public things going in. People can do research to figure out if there's a lawsuit, the brand is tarnished and things of that sort. But again, a company can also incorporate or have their own person, that an attorney or a counsel of staff that could do mediations, or they can hire a third party person, which would be better. To come in and mediate any workplace dispute between, and that's something that I do too, workplace disputes before it goes to before a complaint, a formal complaint is or outside of the organization before it goes to litigation.
Okay, all right. Thank you so very much. So the final question, which is what is your advice for the max advocacy of ADR?
So my advice, and this is the thing, I think that a lot of times people think that when you're doing to find someone who is a mediator for these type of workplace disputes, they automatically think of attorneys. So there's a whole wealth of resources outside of attorneys that are very good with doing workplace mediations, with myself included. I'm not an attorney, but I have that experience. I've gone through the training as well as education. In addition to that, really pushing forward with understanding, I would say maybe in the media or maybe local news or something to gain exposure on the different varieties of options. For instance, you can have a conflict consultant come in that if a company is having a DEIB issue, and actually doing some research on that consultant or that company that's doing the consulting to see how diverse their staff is, to see how diverse their consulting company is. Because if there's not a wealth of diversity to where they can come in and support a company that has diversity issues, then that's not really a good fit. Also, again, going to the ombuds. Ombuds is a great resource, as well as a workplace mediator, a third-party mediator. People have DEIB teams in place that they've established having that in place as well, and making sure that you're giving them the autonomy and to drive success in the company from a DEIB perspective. So they're not just there to save face, but they're there to help build programs, to enforce, to help create policies, all of these things. If a company is really concerned about really helping their company grow from a DEIB perspective and having more diversity and inclusion and equity and belonging, then really having those successful methods in place, those systems in place. So you have a successful company from that perspective is going to have multiple things in place, not just one resource or two resources. They're going to have multiple resources in place so that there's a wealth of options for people to go to if they have a concern.
Thank you so very much for providing a comprehensive overview on workplace conflict. And Chicago is it, yeah? Yes.
Well, I'm from Chicago, but I now live in Texas.
In Texas. So, okay, so was it a case study of Texas and Chicago or just Texas? You know, from case study. From the answers you gave, were you looking at Texas or generally in the US?
I would say generally.
Oh, general. Okay, yeah. So not just awesome. Okay, so I'm right.
General responses. Yeah, I haven't done research from one state to the other, but that's a possibility. I can look into that in the future.
Okay, so thank you so very much for the comprehensive overview of workplace conflict in the US. It has been interesting and engaging and insightful at the same time. I'm so very grateful for you coming on the show.
Thank you.
Thank you so very much. And yeah, all right, you take good care of yourself. Bye-bye.
Thank you for having me. You take care too. Bye-bye.
Yes, you too. Bye.